In the previous section, we explored how buyers can obtain essential reports to assess property condition, such as inspection, environmental, and disclosure documents. These tools allow buyers to evaluate the physical and environmental aspects of a property before closing. Now, we turn our attention to one of the most critical documents in any Arizona real estate transaction, the preliminary title report. While property condition reports reveal what is visible, the title report exposes what is recorded. It provides a complete picture of the property's legal status, ownership history, and any encumbrances that could affect the buyer's ability to take clear title. Understanding the information contained in this report is fundamental to ensuring a lawful, marketable, and insurable transfer of ownership. A preliminary title report, sometimes referred to as a prelim, is prepared by a title insurance company shortly after escrow is opened. It serves as an initial commitment to issue a title insurance policy once the transaction closes, provided certain listed conditions are satisfied. The report outlines the current legal ownership, the legal description of the property, and all recorded matters, such as liens, easements, taxes, and covenants, that may impact ownership rights. Under ARS, Paragraph 6, 841.02, licensed title companies must provide accurate and complete title commitments and are regulated to ensure consumer protection and transparency in all title transactions. The purpose of the preliminary title report is to inform the buyer and lender of the property's legal condition before the transaction is finalized. It is not itself a guarantee of ownership, but rather a detailed summary of what the title company will insure and what exceptions will remain after closing. Buyers should review the report carefully during the escrow process to confirm that the seller has marketable title and that no undisclosed claims or encumbrances exist. The standard Arizona Association of Realtors (AR) residential resale real estate purchase contract requires the seller to provide a copy of the preliminary title report and for the buyer to have an opportunity to review it within a specified timeframe. If issues arise, the buyer may object in writing, and the seller must either resolve them or cancel the contract. A preliminary title report typically includes several key sections, each serving a specific function. The schedule. A portion lists the effective date of the report, the name of the current vested owner, the legal description of the property, the proposed insured parties, usually the buyer and lender, and the title policy type being requested. For example, Schedule A may identify John Smith, a single man, as the vested owner and describe the property as Lot 14, Sunrise Meadows Subdivision. Reviewing this section ensures that the correct property and ownership are being insured. Schedule B is the most critical section for buyers, as it lists all exceptions, exclusions, and encumbrances that affect the title. These may include recorded easements for utilities, rights of way, covenants, conditions, and restrictions, CC&Rs, property taxes, assessment liens, and any deeds of trust securing loans. For example, Schedule B might list a recorded easement, granting a utility company access across the backyard or an unpaid mechanics lien from prior construction work. These items remain attached to the property and may limit how the new owner can use it. If an exception is unacceptable to the buyer, such as a restrictive covenant prohibiting short-term rentals, they can object and request that it be cleared before closing. In addition to liens and easements, the title report may reveal judgments or unpaid taxes recorded against the property or its owner. Under Arizona law, recorded judgment lines automatically attach to real property owned by the debtor in that county. ARS, paragraph 33-964. If the seller has outstanding judgments or tax liens, those must be satisfied before closing to ensure the buyer receives clear title. Similarly, delinquent property taxes or HOA assessments are identified in the report so that escrow can collect and pay them at closing. A properly reviewed title report ensures that no financial or legal surprises carry over to the buyer. The preliminary title report also provides critical information regarding title insurance coverage. It specifies the type of policy that will be issued, such as the owner's policy or lender's policy, and lists the title company's conditions for insuring the property. Title insurance protects against financial loss resulting from defects in title, such as undisclosed errors, forgeries, recording errors, or unknown easements. While the preliminary title report identifies recorded issues, title insurance protects against certain unrecorded risks that may arise after closing. This distinction emphasizes why buyers and lenders rely heavily on both the title report and title insurance to safeguard their interests. Contact the title officer if you have any questions or concerns that your client does not understand. Better to know before the sale closes. Arizona case law has repeatedly confirmed the importance of clear and marketable title in real estate transactions. In Watson, Construction Corner v. Amfac Mortgage Corp. Sears, Arizona 1981, the Arizona Supreme Court held that marketable title must be free from reasonable doubt, meaning the buyer should not be exposed to future litigation or adverse claims. Watson Construction was the general contractor that began work on a project financed by Amfac Mortgage. Although Amfac recorded its deed of trust early, it failed to properly complete or give notice of the construction loan, creating confusion about lien priority. When the developer defaulted, a dispute arose over whether Watson's mechanics liens or Amfac's deed of trust had priority. The court held that because Amfac did not strictly comply with statutory requirements designed to protect contractors and materialmen, the mechanics liens took priority over the lender's security interest. The case stands for the principle that lenders must strictly follow construction lending statutes, and that Arizona law strongly protects contractors who improve property by giving their liens favored status when statutory safeguards are ignored. This case, along with Nielsen versus Hassett, Arizier Apino 1994, reinforced that buyers have a right to rely on title reports and that sellers must deliver a title that meets the contractual promise of marketability. A broker's failure to explain or review a title report may constitute a breach of professional duty under Commissioner's Rule R428-1101I, which requires licensees to exercise reasonable care in communicating material information. This Arizona Court of Appeals case, addressing misrepresentation and non-disclosure in a residential real estate transaction. In the case, the sellers made statements and omissions regarding the condition of the property that led the buyers to believe there were no significant problems, even though defects existed that affected the home's value and desirability. After discovering the issues post-closing, the buyers sued. The court held that sellers may be liable not only for affirmative misstatements, but also for half-truths and misleading disclosures that create a false impression, even if some information is technically disclosed. The case reinforces Arizona's rule that sellers must deal honestly and fairly with buyers, and that incomplete or misleading disclosures can constitute actionable fraud. Consider a practical example. A buyer purchasing a home in Scottsdale reviews the preliminary title report and notices an exception for an unreleased deed of trust, recorded in 2015. Upon investigation, the escrow officer discovers that the prior lender never recorded the release after the seller refinanced. If this issue is not resolved before closing, it could create a cloud on the buyer's title. However, by identifying it early through the title report, the title company can obtain the necessary release, ensuring the buyer receives marketable title at closing. Discussion. Why is it important for buyers to review the preliminary title report before closing? Answer. Because it identifies all recorded liens, easements, and encumbrances that could affect ownership rights, allowing buyers to address title issues before completing the transaction. What is the difference between Schedule A and Schedule B in the preliminary title report? Answer. Schedule A lists ownership and property details, while Schedule B lists exceptions, exclusions, and encumbrances that will remain on the title after closing. Why does title insurance complement the preliminary title report? Answer: because while the title report discloses recorded matters, title insurance protects against potential losses from undiscovered or unrecorded defects that may arise after closing. Review Summary: the preliminary title report is a vital tool in Arizona real estate transactions, serving as a roadmap of ownership and potential title defects before closing. It allows buyers, sellers, lenders, and brokers to verify the property's legal standing and address encumbrances or liens that might cloud title. Schedule A outlines ownership and legal description, while Schedule B lists exceptions such as easements, liens, and restrictions. Reviewing this report ensures the buyer receives marketable title as required under Arizona law and the purchase contract. Arizona case law, including Watson Construction Co. v. AmFac Mortgage Corp. May, and Nielsen v. Hassett, reinforces that clear title is a fundamental right of every purchaser. Brokers play an essential role by explaining these reports and ensuring clients understand their significance. By reviewing and resolving issues disclosed in the preliminary title report, all parties help prevent post-closing disputes, ensuring lawful and secure ownership transfer.